So on that note, so Sam, you want to tell us a little bit more about the power of attorney for personal care?
Yeah, absolutely. So the power of attorney for personal care is kind of the other side of the coin, right? The power of attorney for property manages all your assets and property if you're incapacitated. Power of attorney for personal care is the actual decisions for your well-being.
Mm,
So it's very similar in that you're appointing an attorney, ideally having an alternate as well.
mhm,
Again, you can have, two or two alternates, three alternates, right? You can set it up any number of ways.
mhm,
Same type of deal in terms of the conditions that come in
mm,
when the person is incapacitated.
mhm,
But there is a little bit of difference in that you can put specific instructions within the POA for personal care. So here I have one example, which is basically just staying in the residence as long as possible.
mm,
Uh, this is a pretty sort of generic condition that can be added in. You
mm,
can get much more specific in terms of requests with regards to treatment, with regards to what types of medical treatment you're willing to accept,
mm,
what to do in the case of certain medical events. For example, if you're left in a state where there's no possibility of recovery, right? You can have certain end of life instructions included.
mm,
So all of this can go into your power of attorney for personal care.
mm,
But again, I usually recommend not to do any of it. The reason, as I said before, for property, there's so many possible things that can come up that
mm,
putting one restriction could actually lead to more problems or issues down the road. So for example, if you put a care restriction that doesn't account for maybe some medical allergy or condition you have,
mhm,
suddenly fulfilling that condition may actually lead to other problems. And the POA itself now needs to be brought under question, possibly even taken to court for interpretation, because the conditions that were in there don't match with the circumstances that have actually arisen. So I'll generally recommend to people, if you can put this in the hands of someone trusted, a child, a parent, a close family member, a close friend, I would leave the authority with them. You can certainly speak with them and give them a good understanding of what you want for your medical decisions. But and again, this is just my sort of personal take on it. I prefer keeping things less restricted, just to
mhm,
make sure that the power of attorney won't itself come under question, and that the person acting as your attorney will be able to actively make decisions, right, without too much restriction. That's just where I lean. I'll qualify all that if somebody has really strongly held beliefs or there's something that's extremely important to them, of course, make sure that
mhm,
it's in there and that those instructions are written and understood.
mm.
It's just a matter of what makes sense for the individual. And again, same signing process. Grantor signs needs to be in the presence of two witnesses who sign at the same time, and affidavits at the end
Mm.
to evidence the signatures by the witnesses. And that's pretty much it.
Question. So when you talk about those instructions, that sounds an awful like what's called an advance directive. What's the difference between an advance directive and this document?
Yeah. So in some ways, the healthcare directive or the advance directive is the same thing. I actually saw some law firms blogs and websites were saying in Ontario, the advance directive, also known as a power of attorney
Oh,
for
wow.
personal care. Yeah, so it can get a little squirrely because of that. But
Yeah.
really there is a difference in that the power of attorney is a statute created document,
Okay.
right, that hands over the authority to the attorney.
Right.
All power of attorneys do that. They all name an individual to take over as the attorney.
Right.
A healthcare directive can name someone, or it can just be essentially a statement of intention.
Mm.
So the healthcare directive can also be used as sort of a supplementary document. And because it's not created from statute in the same way, so you don't
Mhm.
have the same signing requirements. Healthcare directive can just be signed by the individual granting it.
Oh, wow.
So,
Okay.
yeah, so what sometimes you'll see in a healthcare directive is just a list of the person's wishes, right?
Right.
Like I desire, maybe the person is for religious reasons against receiving a transplant, right? So it'll just say, I would prefer, or my wish is to not receive a transplant, right?
Right.
Or whatever else it is, it's just one hypothetical. But the healthcare directive doesn't necessarily appoint someone. It can just be a list of, if you need to make decisions for me, here are some things to keep in mind, essentially, right? Here are my wishes.
Right.
And what's important to keep in mind with this too is that it's not things are not completely set in stone in terms of, if you put a something in your healthcare directive, there are situations where, for example, the ambulance arrives and begins
Mm.
treatment before the healthcare directive can be reviewed,
Right.
right? I wouldn't look at a healthcare directive or even a power of attorney for personal care as this is definitively 100% what's going to happen in all circumstances.
Mm.
Certainly the people making decisions for you and healthcare providers will do their best, right? Everyone will do their best to follow your instructions,
Right.
but there can be, litigation that comes out of these, from the restrictions not being followed, or, a situation where conditions couldn't be met or whatever it is. So again, that's another reason that I think the first thing, the priority goal, is identifying a trusted individual, right, to serve this role.
Mm.
You can never be completely certain that the document will be readily available in the emergency situation where it's needed,
Yeah.
but you can know with pretty high certainty that they will call your power of attorney, right? At some point, relatively soon into an emergency, they'll get them available or on the phone. So if you have the trust that that person in that emergency situation will make the right calls for you and make the right decisions, that should be enough that you're not going to need additional restrictions, right, throughout the document. So again, each case is different, but to me, I think the highest priority with putting these documents together
Mhm.
is identifying those trusted individuals who can serve that role for you.
Okay, so it's time to wrap up. Yeah, so thank you so much, Sam, for clarifying that. This is really great information, and thanks everyone for watching. As with all our videos, I do have extra information that I include in the description box, so don't forget to check that out, and all the links for these information, for these websites. And I'm also going to include, of course, Sam's contact details in case you want to contact him to do your power of attorney. And finally, if you're new here, don't forget to hit the subscribe button and the bell so that you won't miss out on our upcoming videos. And see you next time. Bye.